Roman law has led a double life. For 1,000 years, it grew and developed with the Roman state. Then, more than half a millennium after the fall of the Western Roman Empire, it reemerged as the legal framework of medieval and early modern Europe, and went on to inspire the civil codes used across 2/3 of the globe today. The pivot that connects these two careers is the Digest, the culmination of the most ambitious project in the history of Roman law. It took 3 years to compile, 3 years during which a commission set up by the Emperor Justinian sifted through more than 3 million lines of legal commentary and condensed them into the definitive compilation of the opinions of the Roman jurists. The finished work, with 9,123 extracts in 50 books, was proclaimed on December 16, 533. It was free, the emperor declared, of errors or contradictions. It would be observed for all time. Roman law had been formalized by the 12 Tables, which dated to the early years of the Roman Republic. From those origins, it had ramified and proliferated, enriched by the edicts of magistrates, the decrees of emperors, and the treatises of jurists. The first attempts at codification coincided with the reign of Diocletian, but it was only under Theodosius II, in the 5th century, that an imperially sponsored collection of laws appeared. The codification of Justinian produced the image of Roman law that would be transmitted to the Middle Ages and beyond. Besides the Digest, Justinian's compilers assembled the Institutes, an elementary textbook for law students, and the Code, a collection of legislation by emperors from Hadrian onward. Together with the novels, laws issued later in Justinian's reign, the Digest, the Institutes, and the Code came to be collectively known as the Corpus Juris Civilis. Before considering how the corpus, and especially the Digest, shaped modern law, it might be helpful to briefly discuss how the law operated in ancient Rome. In the early imperial era, a case between citizens began at the court of the praetor. There were, by then, 16 praetors, 2 of whom presided over the main civil jurisdictions. Some cases proceeded no farther. A praetor could declare a plaintiff's suit invalid, or a defendant could admit that it was just. Normally, however, it was the praetor's task to define the case with a statement known as a formula and to appoint a judge. The judge need not be an official, or even a Roman citizen. He could be almost anyone whose arbitration was acceptable to both parties. Plaintiff or defendant could suggest a candidate. Alternatively, the praetor could select someone. Sometimes 3 or 5 judges were appointed. An especially prominent case, particularly one that dealt with a disputed inheritance, might be brought before the court of 100. Whatever the arrangement, the judge or judges set a time and location for the trial. On the appointed day, the plaintiff and the defendant appeared with their advocates. The lawyers orated, witnesses and written testimonies were brought forward. When the dust had settled, the judge, who was usually not a legal expert himself, might consult with 1 or more men known to be learned in the law. Then he rendered his decision. The state would not enforce the verdict, but if the plaintiff did not receive his due, he was entitled to personally imprison the defendant and sell his property. Especially later in Roman history, when more scope was given for appeal, the wheels of justice turned very slowly. Theodoric once ended a suit that had dragged on for 30 years by threatening to execute both lawyers. And, in all periods of Roman history, the law favored the rich. Besides having the resources to weather the legal process and the social capital to influence judges, the elite were formally categorized, from the 2nd century onward, as honestiores, the better sort, and were exempt from the worst punishments. The laws themselves, however, were remarkably sophisticated. Nearly a quarter of the Digest, for example, was taken up with the legal intricacies surrounding wills and succession. Contract law was also impressively nuanced. In itself, of course, complexity is no guarantee of quality. But, as outlined in Justinian's corpus, it at least conveys a determination to apply the law to every contingency. We'll explore how Roman law came to be adopted throughout medieval Europe and beyond, after a brief word about this video's sponsor. Before Justinian codified Roman law, litigants and lawyers had to scroll through, well, scrolls, to find legislation. Finding information is much easier today, and it just became faster than ever before, thanks to Agent AI. Agent AI builds, and helps users build, specialized tools to enhance productivity. I asked the developers to help me make an ancient Roman calendar, an agent, in other words, that could tell me the festivals and anything else noteworthy that took place on a given date. And they have. Taking January 1st as our example, you can see that the agent not only lists the day's festivals, but also indicates whether or not legal action was permitted. Check out my Roman calendar agent, powered by Agent AI, by following the link on screen and in the description. Returning to our topic. In the Byzantine Empire, the Corpus Juris Civilis was condensed and translated into the Greek code known as the Basilica. But in Western Europe, where Justinian's laws had never been widely used, the corpus was virtually forgotten until the mid-11th century, when a manuscript of the Digest surfaced in Italy. Within a few decades, scholars at the newly organized University of Bologna had begun to study and teach Roman law. Aside from the prestige of its association with the ancient emperors, Roman law had considerable practical appeal. Merchants appreciated its provisions for the enforcement of contracts. The Catholic Church used it to streamline procedure in ecclesiastical courts. And lawyers across Europe, confronted with a system so complex that it could be used to argue almost any position, found Roman law very much to their liking. Roman law came to be accepted through much of medieval Europe. Although local practice continued to vary, Roman law provided a common framework for legal decisions. This was especially important in politically fragmented Germany, where the Supreme Tribunal of the Holy Roman Empire settled all cases in accordance with Roman law. In England, by contrast, the power of the king and the king's courts had consolidated relatively early. As a result, by the time Roman law swept across Europe, England already had a well-established common law tradition, which it maintains to this day. On the continent, Roman law was gradually displaced by national civil codes. The most influential of these appeared in 1804, when France adopted the Napoleonic Code. Over the course of the 19th century, this provided a model for the national codes of the Netherlands, Spain, Italy, Belgium, and much of South America. The newly unified German Empire continued to use Roman law until 1900, when the German Civil Code was promulgated. This, in turn, was imitated by many countries, including Japan and Brazil. Some countries resisted the tide of codification. Until 1946, Greek law was based on the Hexabiblos, a late Byzantine abridgment of the Code of Justinian. The Ethiopian Law of Kings, also inspired by the Byzantine incarnation of Roman law, remained in effect through 1960. Versions of common Roman law, that is, Roman law shaped by local usage, are still used in the microstates of San Marino and Andorra. Vatican City follows Catholic canon law, modeled on but independent of Roman law. The law of Scotland, though heavily influenced by English common law, contains many Roman elements. Roman law also remains in effect in several former Dutch colonies, notably Sri Lanka, Guyana, and, to a lesser degree, South Africa. More generally, all the national civil codes created in the 19th and 20th centuries are descended from the Corpus Juris Civilis. The French Code imported many concepts from the corpus, as refracted through the lens of natural law. The German Code, likewise, can be understood as a systematic rationalization of the Digest. In this sense, the basic elements of Roman law still serve, as they did in medieval Europe, as a common frame of reference. England and many former British colonies follow the common law tradition, as, with the partial exception of Louisiana, does the United States. But even in common law jurisdictions, the ideal of the law as a secular, rational, all-embracing system comes to us from the Romans. Law is still defined, in the words of the Digest, as the ars boni et aequi, the art of integrity and equity. In the spirit of integrity and equity, you owe it to yourself to check out the Toll & Stone Patreon, where you'll find much more historical content. There's a link in the description. You'll also find links there for my 2 upcoming group tours, which will visit, respectively, the remote ruins of eastern Turkey and the rather less remote ruins of Rome. And, on the off chance you're still listening, why not take a look at my sadly neglected other channels, Scenic Routes of the Past and Toll & Stone Footnotes. You probably won't regret it. In any case, thanks for watching.